all for the Knowledge Tuesday session. I'm Archana from HTIC MedTech Incubator hosting this session. Before we start, I would request all the participants to kindly stay on mute and please unmute yourself while you speak. We have also created a feedback form for this session. We'll be posting the feedback form link in the chat box, requesting the participants to please fill during the end of the session for us to improve the upcoming Knowledge Tuesday sessions. For the today's session, we had speaker Mr. Anand, who is about to join along with his colleague Roy for the today's session, but unfortunately at the last moment he couldn't able to join us due to some emergency. So we have Mr. Navarre Roy, colleague of Mr. Anand. He's a managing associate at Anand and Anand. So we'll be having Roy to take over this session. And the topic for the today's session is legal issues on his HR and co-founder agreement. Over to you, Mr. Roy.
Sure. Thank you very much, Archana. Thank you for putting this together. And also, yes, I do apologize that Bharat couldn't make it today, but yeah, thank you anyway for roping me in on this one. All right. So for today's session, the topic that's there is on legal issues with regard to human resource management or HR, and specific issues on co-founders agreements. So before we actually go into the session, I just wanted to know, at least maybe if you guys could just drop in on chat or either unmute yourself and just let me know one at a time. I think perhaps chat would be better. But how many of you on this, I see there are about 27 participants. How many of you already have created some sort of entity or are dealing with creating your business with someone other than yourself? That is, you have maybe a co-founder. Could be a single co-founder, it could be more than one co-founder, but how many of you are in business with someone other than yourself? If you could maybe just drop a chat, that would be great. Or if you could unmute yourselves and let me know, that would also be great. I'll leave that out to you. So I see there's one response who Mr. Susinder, I think, right? You've got a co-founder as well. Anybody else doing business with someone other than themselves? All right. Arun Kumar Ramaswamy, all right. You've also got a co-founder. Okay, perfect. Rahul Arvind has two co-founders. Excellent, wonderful. Ehas is looking for a co-founder. Very good, good indeed. Okay. Anybody else on the list? Shobha, all right. So you've also got a co-founder and for your business. Excellent. So that puts us at 1, 2, 3, 4, 5. All right. We've also got Professor Jnana Krishnan, who says co-founding Aspire, what is the most basic? Okay, that's come to a question. I'll deal with questions eventually. But it's good to know that, okay, Jebin Samuel's also looking for a co-founder. Perfect. All right. So at least from the chat that you guys have sent across, I know that at least there are about 5 to 7 of you who've got co-founders. I don't know whether they're also in on the session or not. But so what today's session is going to cover, and I'll just try and share my screen as well at this point, is we're going to cover 2 basic issues. Just 1 second. Yeah. All right. One is on co-founders agreements, what the need is, why we need to have them, what are the types of co-founders, what are the co-founder disputes that commonly arise, and what a co-founder's agreement needs to have. So that's going to be on the first segment of our session, followed by the general things that we need to look at when we're dealing with HR or human resource related issues in terms of the agreements, the policies, and possible disputes as well. Right, so that's broadly in terms of what we will be covering today. And so to kick off the session, I guess, yeah, we'll first deal with co-founders agreements. So in terms of co-founders agreement, it predominantly is very simply an agreement that governs the relationship between 2 or more co-founders who come together to start any particular business, right? So the question is, why do we need it? If you look at whether or not there is in fact a need, you will find that a very simple reason for the need is the fact that there are about 65% of all startups that fail, that is, the startups that haven't done well, almost 65% of them relate to disputes between the founders, right? So anyone who started the business, once they're in it, after a particular period of time, there are disputes in terms of the management, in terms of the way that it's run. There are multiple disputes that we'll also be covering. But broadly put, that's more than half of the problems that failed startups have is disputes with their co-founders, right? And the reason is when you're getting together for the first time, or when you're just discussing an idea and discussing plans, everything seems very optimistic. But if you don't have an agreement in place, or if you don't have something written, chances are you're not going to be able to foresee all possible avenues of how this is going to go. And the other important thing is priorities, right? A lot of the times you may be starting this off while you're working somewhere else or in conjunction with something else that you're doing. So in that case, your priorities may change. So it's always good to have a co-founder's agreement in place, or an agreement in place that's going to govern how things are going to work. So, all right. So according to the book Founder's Dilemma by Noam Wasserman, there are different types of co-founders that are commonly there in terms of the businesses that you find. I've put together a few of them based on that categorization, as well as some of the logos, which we can possibly go into. So broadly put, we've got different types of founders of companies, or organizations, or entities. The most common one, of course, is friends who've been two or more individuals who've been friends for a considerable amount of time. I'm talking maybe school together, college, and then work together possibly, and then setting up a business. That's the common type. You've got the type of co-founders where one is the star and the other is the brain, which is a good combination, where you've got one person who's very charismatic and the other person who's pretty much the brains behind the show. You've got husband and wife couples starting businesses together. You've got college buddies or college friends starting together, people who meet together either at engineering or MBA or wherever they are studying together. And you've got siblings who start businesses together, right? So this broadly, just in terms of the classification or the types of co-founders that you have. And there are one more type where people are brought together by, say, venture capitalists or friends or common. I do notice that a few of you said you were looking out for founders or looking out for partners to work together. So you could be connected through mutual friends, or through where you don't have any background put together other than what you do eventually find. So with regard to this, I would like you all to see, so there are a few logos over there, Ben & Jerry's, HP, Airbnb, Housing, Flickr, Apple. I would like the session to be a little interactive. So if you could let me know which of the categories that you think these individual businesses fell under. So if I were to say Ben & Jerry's, do you know whether the co-founders were friends, whether it was a combination of star and the brain, husband and wife, college buddies, or siblings? Does anyone have any guess as to Ben & Jerry's? You could unmute yourself and mention it. You don't need to chat at this point. All right, I see a message from Rahul. Yeah, go ahead, Rahul.
I think they were friends.
That's right. Ben & Jerry's were friends right through school. Ben & Jerry's, for those of you who don't know, is an ice cream company, and they were founded by friends. That's right from school. What about the next one, HP? Any guesses on HP? Does everyone know what HP stands for? Okay, I see there aren't any takers for, yeah, Hewlett Packard, that's right. Jnana Krishnan, that's right. Hewlett Packard, that's right. Were they Hewlett Packard, were they friends? Was it, what sort of combination of co-founders do you think they were? All right, since I'm now getting a response, well, Hewlett Packard were also friends, right? What about the Apple logo? Apple, with any guesses on which sort of classification they would fall under in this case? Star in the brain, that's absolutely right. Steve Jobs and Wozniak, star in the brain. Spot on. Okay, we'll go to one closer home, housing.com. Any guesses for the housing.com startup that was based out of India, in fact? It was the only one on the list which was an Indian company to begin with. All right, housing.com was started off by IIT colleagues, all classmates from college as well. So they would fit under the college buddies. You've got Walt Disney. Walt Disney is siblings, Roy, Walt, and Disney. Facebook, again, college. Warner Brothers, pretty straightforward brothers, so siblings as well. So the idea is people come together to start a business either when they've got a good idea or where they've got a sort of business plan in place. And this could be the family members, it could be your friends, it could be a couple, like as is the case of Flickr, Airbnb, friends who found themselves on Craigslist. Whatever the reason is, you're brought together in terms of starting of a business. And when you're coming together to start a business, or to start a research project or to start anything for that matter that is of value, it's important that you set certain ground rules, particularly if it's a business. When you go to work, or if you're working, if you're employed somewhere, you can always segregate your life easily, saying, this is my work and this is not personal. Whereas if you're starting a business, it is always personal because it's something that you're creating. So moving on to what we have in terms of the most common co-founder disputes. Whenever you've got two or more individuals getting together, starting a business, there are certain common general disputes that come up, right? The number one and the most important thing is, what do you and I get, or what do we get out of this? And this could be in terms of this could be in terms of the revenue, this could be in terms of the profits, this could be in terms of anything that you're getting out of the business. What is it that I get? What is it that you get? And how much of it do we each get? Is it going to be a split that's down the middle 50-50? But it never really is down the middle 50-50 because somebody's contributing something else. Someone's contributing in terms of funds, someone may be contributing in terms of technology, someone may be contributing in terms of business and network. So it's important that you identify what each of you is planning to get out of this and what each of you wants out of this. The second most common co-founder dispute is dispute on who works harder or who takes something seriously. Very often you'll have two people get together, maybe start off a business while one is still working or fully employed somewhere and just doing something over the weekends, whereas the other person may have quit their job and is working full time. So then it comes up, the common dispute is whether or not, who's working harder, who's taking this business more seriously, and that could be a, a ground for conflict, right? The other one is who gets to decide. If you have two or more individuals and we're presented with a problem, who gets to decide which course of action to take? This is also a very common dispute that comes up when you've got two individuals. One maybe is more on the investment side, the other is doing the research, and then all of a sudden there's a decision that the company needs to take with regard to investment. Who has the final say? It may be fine if you've got more than two. Say, for instance, you have three co-founders, then in that case you could have a vote of sorts. But if you have only two individuals, who's deciding what? That's a common conflict. The other one and most common one is when you're going through a rough patch. And this is like with anything else in life, you are bound to go through certain rough patches, and your business is also likely to, whether it's a pandemic like what we're facing, or if it's a change in market or change in technology, whatever it is, when things get tough, more often than not, you'll find that maybe one of the co-founders is fine with just letting the whole thing go, letting it sink, or the other may be willing to put in extra to go ahead, or maybe both are willing to put into it. Both are willing to add more and get ahead. So in that case, it really comes down to, when things are going tough, are you all on the same page, right? And more often than not, this could be a source of conflict. And the final, or the fifth most common dispute is when, say, after a point, you just don't get along with your co-founder. It could well be that, you've just had too many conflicts, or you may have started this off when things were really nice, when you were sitting and planning things in college, and then things are just not working out in real life because everybody has different priorities, has different background, have different expectations of both of the business as well as their personal lives as well. So these are the most common. I know there are so many more, because like any human interaction can have different conflicts. These are probably the most common co-founder disputes that are there. So why do we need to look at the disputes? The reason we need to look at the disputes, and the reason we need to look at what could go wrong, is so that you can protect your interest right at the start. So on day one, when you're sitting and discussing, and on day one, when you're setting up your business, you would be in a position uh, to identify, okay, fine, this could be a potential for conflict. How do we resolve it right now? And to discuss what long-term goals are, and to put that into an agreement. And the reason is, these putting this together will help you draft the agreement in a way which would be specific to your relationship with your co-founder, and what your plans are for the business. Right. So we just move into next, the anatomy of a co-founders agreement, right? So this is what a good co-founders agreement should have. I'm sure if you search on Google, you'll get a bunch of contracts that are easily available. Each of them, with a template. But the thing is, a template really doesn't cut it, because this could be very specific and personal to what you are doing, what you are contributing, and what your co-founder is doing as well, right? So the number one thing that needs to be there is who gets what. That is, what is your split of the business? Are you going to be equal shareholders? Are you going to set up, first up, is it going to be is this going to be a private limited company that you're setting up? Are you setting up just a partnership? If that's the partnership and not a private limited company, who's investing? And also, what share of the company or the entity are you getting? That's number one that you need to decide, discuss, and have in your agreement. The next one is who contributes what. And that's important, because, like I said, each of you will be bringing different things to the table. It's important that you document it, identify it, and also evaluate what each of you is bringing to the table. So if someone is, say, in a combination where you've got someone with a research background, someone who's got more software development skills, someone who is good on the business front, each of you need to identify what you're good at, what you're contributing, and put that down, saying this is what's going to be done. It could be cumbersome to try and list these things out, but it's really good, because it will give you an idea as to what working together is also going to be like, and what's going to happen. The next thing that you need to have is clauses on what the roles and responsibilities are of each of the co-founders. Now that you understand who's contributing what, it's important that you set down those roles and responsibilities. So if someone is in charge of something, it's best to segregate, and you will have overlaps, of course, but it's good to have a clear set of defined roles and responsibilities that are separate from each of you, so that you're able to achieve them. If it's not written down, if it's not decided or discussed, then it can be very ambiguous. And sometimes you could be frustrated with your co-founder just because you may expect them to do something when in fact they feel it's not their responsibility to begin with. So it's good that you sit and hammer this out at the start and fix these roles and responsibilities. The next thing, of course, is who decides what. Now, for instance, you may have, as with anything, any business or decision that you're making in life, you may have multiple options available. So the question is, who decides what's best for the company, or who decides what? You can have a segregation. Say, if it's investment related, it might be decided by one individual, because it's if both of you agree on, or three of you or four of you agree on the same thing, then there's no issue at all. But if you do have differences of opinions, then whose opinion does get taken? So you can segregate that into, say, headings. If it's investment related, if it is market related, if it is going to be related to certain aspects, then maybe one person's decision trumps the other person. It could be something that you decide that way, or a fair and equitable method that you can decide and come up with where you're at loggerheads, right? And that'll be very specific to you and how you work with your co-founder. The next thing is on profits and losses. This is really important as well, because when you do hit a rough patch, it's important. When things are going good, you need to figure out who's getting what. But when things go bad as well, how you're going to work with your co-founder, and how are these losses going to be absorbed? What happens if you do face losses? It's good to sit and evaluate that at the start. The next, an important thing, even though it might be a little hard, is to sit and clarify what happens when obligations are not met. So we all know that, there are certain grades, right from schooling to when you're working. You've all got individual goals to accomplish. If you fail in those goals, you could receive a lower rank if you're in school, or if it is at workplace, you could have a tough conversation with your boss. But whatever it is, you have your obligations or your KRAs set, and then you need to know whether or not you're matching up with them. But what happens if you're not matching up? Say, for instance, you do have co-founders at the start of the business. One of your co-founders was doing really well. They were dedicating a lot of time doing all their roles and responsibilities, right? Over time, that's been deteriorating for whatever reason. Maybe they've lost interest in the business. Maybe something else is going on. But what happens if they don't meet those obligations? You do need to have a provision in your co-founders agreement which talks about this. And more importantly, is there going to be a certain amount of time that they're going to be given to remedy this or try and hit their obligations again? Or if that doesn't happen, are you going to reduce their share in the company? Is there going to be a separate drop in the salary? Is there going to be a drop in change? Whatever it is that you sit and discuss needs to be there, because this is important. Otherwise, you'll end up having individuals who are not contributing to the company, but still on the company for the simple reason that they were there with you when you started it, right? The next thing is to decide and to discuss what happens when investment comes in. So if you are looking at investment, and this is something that most companies end up doing, particularly if you are starting off your business, you would be looking at trying to bring in investment at some point in time and space. So in that event, what happens when you are planning on bringing in any amount of investment is, the very first decision that you need to agree on is whether or not you do need the investment, because along with a certain amount of investment that comes in, it also means you are losing a little bit of control over your own entity that you've created, right? So right from the decision as to whether or not to take an investment, to what amount would be acceptable. Sometimes you may have a co-founder who is not keen on taking venture capital funding, but may be keen on taking in loans, or keen on family investment. So all these things need to be discussed and decided, so that you agree on what would happen when investment comes. Are you going to dilute your shares? What is the what happens in the event that money is going to come in, or you're bringing it in a particular way, right? And the final thing also is in terms of individual exit strategies. And I'm not talking about exit strategies, say, when investment comes in and leaving. I'm talking about when one person's not performing, or one person's no longer interested, or where things are not going too well. You need to have a way of deciding what's going to happen in that case. Are you going to sell out your shares to the co-founder? Does the other person still want to run the business? If one person wants to run the business and the other person does not want to run the business, then in that case, what happens? Can one person buy out the other person's stake? These sort of things as well need to be thought of and agreed, and therefore also they're in an agreement. So this might seem a bit heavy, and you may also have it may seem like a lot to do at the start, but it's important that you hammer this out. The other thing that you also need to look at in terms of the co-founders agreement, which I haven't listed over here, is on how you are going to resolve a dispute, if there is a dispute with regard to your strategy itself. So for instance, you can have options such as mediation, such as arbitration. You can sit and decide, maybe you have a common mentor, maybe you have a common venture capitalist who's a mentor, who's mentored your business. You can set those dispute resolution mechanism in this co-founder agreement as well, so that you say, if you've got this dispute, let's go and discuss it here, let's go to mediation, let's go to conciliation, let's try and figure out a solution, so that the business continues to run effectively, and more importantly, that your business sort of thrives and does well. So it's important that you set these out. And while these are the broad things that's absolutely essential to cover, the reason I listed these out is because you will find, like I said, in today's day and age, you will be able to find drafts of agreements online. It's fairly straightforward, but it's important that you hammer out these issues and discuss this at the start with your co-founder, with your partner, wherever it is, uh, so that you at the start of it. So you're able to identify the potential issues, identify what you're going to do with these issues, and then still go ahead. Because a lot of you may when you're discussing these itself identify sources of conflict. You may understand that when it comes down to bringing investment, which is something as fundamental as that, you may have contrary decision or a belief as compared to your partner. And when you're sitting and discussing at this stage, you're in a much better position discussing this now and deciding it, rather than after spending 1.5-2 years in, and then realizing that your partner never wanted investment in at any point, and that was an integral part for you. And so it's important that you discuss this, clarify it, and put this down in writing, so that whatever happens. So for instance, say you set up a private limited company after this. Now, the way that a private limited company is run and disputes between directors is handled under a separate law, which is your Companies Act. But if you have this agreement in place, it'll give you an overarching understanding of how things need to be and what you've already agreed on. Right. So that's with regard to co-founders and disputes and the co-founders agreement. If you've got any questions at this point, I see we're halfway through. So if you've got any questions on the co-founders agreement, maybe I'll wait for about 2 minutes. We'll try and take them right now. Or if you prefer having the questions at the end, I will leave that to you as well.
Roy, we'll take the questions at the end after you complete the HR.
Sure. All right. Okay. No worries. I'll go ahead. All right. So the next aspect that we're looking at is in terms of the common legal issues when when you're managing people, right? Managing people and managing a business, managing people as a part of your business is an important aspect of your day-to-day work when you're setting up a company or when you're running your own business. And there are certain things that you should do. There are certain things that should be in place. And so both from a legal perspective, from an ethical perspective, and so what we're covering right now is going to be the things on the legal front. I do believe on the previous session we covered certain general things about your PF and your more statutory requirements with regard to PF and gratuity and things like that. Whereas what today's focus is going to be on is general things like your policies, your agreements that you need to have in place, and the common issues that arise and what needs to be done when you're dealing with people who are working for you and working for your business, right? Okay, let's take this in stages. And the number one thing is when you're signing up an employee, when you're getting someone to join you. And this is different from your co-founders agreement, obviously, or your co-founder, for the simple reason that there's someone you're starting business with. Here you're employing someone to do a fixed task that you've got for them. So it's important when you're onboarding anyone, and these are general things that you need to look at now that you will be running your own business, is always have application forms in. Simple reason is it gives you where you can create one even on Google Docs today. Straightforward thing where you get details from an individual with their own representations of what they are bringing to the table. So for instance, if they're talking about their personal details, if they're talking about their qualifications, things like that, it's always good to have a record of that because tomorrow if you do have any, if something doesn't tally or doesn't match up, you would at least have a base to say that you represented that you had this, right? So it's important that you have an application form, something where they represent, where your potential employee represents all the details that they've got. The next thing, most commonly people do is have details of, their copies of their mark sheets, graduation details, previous employment, things like that. Again, that's important that you have these questions there on the application form, which is there on your record as well. An important thing is if you're not hiring someone fresh out of college or fresh out of school, it's important that you have, if they are employed somewhere, it's important that you have a clear relieving letter or a letter of employment with a resignation letter from their previous place. You never, for the simple reason that, you're in the clear that the individual that you're hiring is actually going to be working for you full time, that they're not working in two different places, or more importantly, maybe they were relieved from their previous organization on account of something terrible that was done, maybe a crime or whatever it is. It's important that you have clear proof that that particular individual is no longer employed by their previous person. The next important thing to do is to have background verification done. And the background verification is you'll find bigger companies that do background verification by engaging third-party companies. You have other third-party service providers who do a host of background checks, including going up to the police station, local police station, finding out if there are any crimes filed and things like that. So that of course would depend on your line of business and the extent that you need or would like to get a verification done, right? Because obviously you can't physically go and do these verifications. It doesn't make any sense to you. Plus, you may not necessarily know where to look. So it may be worthwhile in reaching out to and tying up with an agency that does this. But it's important that you do the background just to see a couple of things, to see whether the information and the representations that they've given you is accurate, to see and to make sure that there's no discrepancy, that there's no glaring issue, that there are no crimes, there's no the person's not accused of any crime that could be problematic in the future as well. And then the next important thing is always have an offer letter and an employment agreement. This is absolutely essential. It's essential from several aspects. One is you're listing out what the terms are, what the terms of employment are. It's good to put in your salary, your bonuses, whatever it is that you're going to look at. And also, since you all deal with IP or intellectual property led businesses, it's good that you have clauses on intellectual property in your employment agreement, which categorically state that all the IP that's created during the course of their employment vests with your company or vests with your entity. So it's good to have this. Plus, the other thing is importance on your employment agreement needs to have clauses on non-solicitation and non-compete, for the simple reason that you don't want them poaching other clients or employees of your company and your clients and running away and starting off a separate entity of their own. So you need to have clauses on non-compete as well as non-solicitation. It's almost essential that you have clauses on confidentiality as well. Simple reason is that you wouldn't want your confidential information out there, either with a subsequent employer or if your employee was to leave and start something on their own as well. So you would want, it's important that you have this clear, where you have a clause on confidentiality as well, and non-disclosure of confidential information in your employment agreement. Another important thing is clearing out things like your probation. What is the probation period that you're giving? What is your, is there a process of getting you as a confirmed employee, or is it just a one shot that way? An important thing on notices as well. If they are resigning or if you are firing, please clear what notices are like, because your notice period is something that decides in terms of both your liability if you need to end up paying your employee if you fire them, provided of course there's no valid ground, and at the same time if they need to jump as well, if they need to give you notice, what that actually means in terms of the salary consideration and things like that. So it's important that you have this in place and you have this drafted and you have this readily available so that you have it signed and executed by every one of the employees. It doesn't matter what their designations are. It doesn't matter whether they, whether they're close friends or whether they refer to you through family members. It doesn't matter, because at the end of the day, you need to have something in writing to show that you have engaged this individual for a certain period for a certain service as well. So typically all agreements, whether it's a co-founders agreement or your employment agreement, any agreement usually comes into place or is required when there are problems or when there are disputes. When there's no dispute, when you've just met someone who's a great fit for your company, you talk to them, you like the way they sound, you want them to join on board. At that time, nobody gets into looking at the terms of the employment agreement or whether or not it's given. But it's only when they start underperforming, or if they start doing something against the values of the company, only then do you suddenly realize, oh, I don't have an employment agreement in place. On what grounds can I ask this person to leave? Things like that. So it's best that you have this standard for everyone that you engage with. If you don't have employees directly and you have consultants working with you on a regular basis, it's absolutely essential that you have those agreements with the consultants as well. It's good to have that in place. Just remember that any relationship that you have, any business relationship you have, whether with your clients, whether with your employees, whether with your consultants, it's always important that you have an agreement in place, something in writing that will be there in writing to govern your relationship and to make sure that when there are any disputes, they can be resolved in an effective manner. Right. The next aspect that you need to do and that you need to start looking at when you're running your own company is setting up your policies. Now, policies, that you have multiple policies, but it's absolutely essential that you sit and decide what your business is going to be like, what your culture is going to be like, what is expected of your employees. So for instance, let's take point number 3, which is the standing order, which is the rules that govern all things of your company. So whether you've got a leave policy, and the thing is, when you're beginning, it may seem cumbersome. It may seem like, you've only got 2-3 employees. Do I really need to put this in place? But it's absolutely essential. You need a framework in place, one, for order for the employees to also understand, and 2, you'd also need this so that in the event that someone does not meet the expectations of either the policy or the rules, you wouldn't have a ground for actual termination. Because if you don't have anything decided, if you don't have anything discussed or anything in writing, then you cannot expect someone to live up to an expectation which isn't even communicated. So it's absolutely essential that you have your policies in place, whether you've got a method for grant of leave, the way that you apply for leave, how many holidays individual employees are entitled to, what about overtime? Is there a concept of overtime? What are the work days that they're expected to work? Important ones on maternity benefit. So there are certain statutory requirements, or there are certain legal requirements as well that need to be met. For instance, under maternity benefit, as of now, you have to, all companies are, rather all women employees uh, who are pregnant are entitled to 180 days worth of maternity break. So that's a paid amount for 180 days, right? So that's mandated by the government. It's important that you have this in place. It's important whether you choose whether or not to have a paternity leave policy in place as well. It's absolutely essential that you have one of this. In addition, it's mandatory that you have a sexual harassment committee and a policy on the basis of that, so that you list out what happens when there are complaints, who's the committee that's going to evaluate these complaints, what is the investigation that is going to take place, and what would happen if someone is, say, found accused and guilty of that as well. So you need to have policy documents in place. And this, again, while you may quite easily get certain drafts on the internet, it's important that you sit and understand and discuss this with your co-founder or individually and put this down, because this is going to set the blueprint for the way that your business is going to be run, for the way that your company is going to be run, and the legacy that you're sort of leaving as well. Because as you grow, as you take on more and more individuals into your business, these rules are what's going to be guiding them across. So it's important that this is in place. A simple thing on in terms of overtime that I mentioned right now is if you do have, say, if employees working overtime or beyond a certain period of time, and you've taken responsibility of dropping them home, for instance, you need to know that as of now, the rules state that if you do have an employee who's a woman, she has to be dropped directly at her doorstep and not at a common location where she can then find her way on. This is after a certain period of time, as well as, you're supposed to provide security. If it is a cab operator that you're going through, you're going to need to do background checks of the cab as well, the cab service provider. So it's important that you understand that all of these things need to be discussed, decided, documented, and in place, so that when you and your business grow, you'll have a framework of rules for you to be for it to be governed by. Right. The final aspect of the final aspects of what we're looking at for today is in terms of what happens when there are disputes with your employees. Typically, you've got labor court disputes where, say, your employee takes you to the labor court when they allege any of the, if you haven't, say, followed the rules properly, or you've also got possible criminal and possible civil disputes that come up. So the number one most common one that you will see is, performance failures and having to let people go when they don't hit their targets or when they don't do what is required of them. Obviously, this is something that's very subjective. You may feel that performance isn't up to the mark, and they may disagree for whatever reasons that there are. So if there is any issues with regard to that, and you do have to let someone go, then in that case, okay, then in that case, I'm sorry, I'm getting some feedback, but yeah, in that case, there is a possibility that your employees may take you to court or file a criminal complaint if they feel, they've been wronged in some particular way. The other thing is what happens if you find your employees swindling money or taking property or doing anything illegal during the course of employment. This could also be a huge problem. And this would, you would invariably have to go a criminal route if that's something that you do find happening on your within your business as well. Payment of dues, this is a common thing. Say, for instance, someone does resign, they don't give you the necessary notice period, or they do give you a certain amount of notice period. They expect a certain amount of back payment, or they expect a certain amount of bonus which is pending, things like that. Have you, when you're letting them go, to make sure that you have an agreement as well, or a letter settling all disputes done and dusted, so for instance, so that there's no claim coming back to it at a later period. Right? Notice period concerns, this is also fairly common. Someone wants to resign, and then all of a sudden, within 5 days, they stop coming, but they claim money for the entire month or for the entire notice period. Things like this. A lot of legal notices go back and forth, and labor court disputes go back and forth on whether or not notice period salary has been paid. Improper firing. This is again, if that's why it's important that you have the policies in place that I mentioned in the previous slide, because you need to set down what is expected of your employees as well as what is not accepted of your employees. So if they don't have that clearly, say for instance, maybe an issue like bribery is an absolute no-no, and you may want to have that in your policy there, saying anti-corruption in terms of that. And then if you don't have that listed, and you've got an employee who's like, no, this is India, everybody does it sort of attitude, they may not know that the company has a no tolerance policy to that. So it's important that you have those policies in place, so that even if you are letting someone go, it is in conjunction with those policies, those rules, and those standing orders that you have in place, right? So in the event that someone accuses you, an employee accuses you of an improper firing or of them being let go improperly, you'd have something to fall back on saying, no, this was in violation of X, Y, Z of our own policies. The next important thing in terms of disputes that we do have is having employees take away confidential information. And that's increasingly common, as well as more and more important as days go by. You have your client list, you have your research work that you've done, you've got your business secrets, whatever it is, whether or not they're going to use it with a competitor, or whether or not they're going to set up a competing business, or whether or not it's just a tool for making a demand for whatever it is that they want, some sort of leverage in negotiation. Say, for instance, you've let go of someone who wants additional amounts of money, but they've got your laptop or desktop and have all confidential information. They could say, we'll give this back to you, provided you give provided you clear XYZ or pay me a certain amount of money. So these sort of disputes do happen, and broadly put, it either goes through to the labor court, which is effective in dealing disputes related to employment, or it could be a criminal dispute, or it could also be a civil dispute that comes up. But broadly, these are the common issues that you're likely to face if and when you run your businesses with more than family members, or in fact, even with family members, with more than 2-3 individuals in your business whom you employ. You're likely that you may or may not face one of these concerns. Right. So with that, I think I am done for the day, leaving us with about 13 minutes, I do believe, or actually 11 minutes for questions.
Yes, Roy. Thank you so much. So we'll take the questions. We have a few questions in the chat box.
Sure.
We have the first question from Jnana Krishnan. So, what are the
Right.
most basic legal issues on HR faced by startups, and how to overcome that?
Yeah, okay. So the most basic ones that we'd have would possibly be not having agreements in place, not setting out your expectations and deliverables of your employees. So that's why it's absolutely essential that you have an employment agreement, because you need to set out what their roles and responsibilities are and what your company policies are, so that you're able to identify and understand whether or not they're living up to those expectations or matching up what needs to be done. But predominantly, it is on performance issues. That's the most common set of conflicts that we have, or this common set of problems that we would have with employees and startups. And in terms of overcoming that, like I said, it's best to have an employment agreement in place. It's best to have your policies in place and a mechanism for resolution of these sort of conflicts.
Thank you, Roy. So we have few questions lined up from Jnana Krishnan. So, sir, can you please unmute yourself and go ahead with your questions? Jnana Krishnan, sir, can you please unmute yourself and go ahead? Okay, we'll take the questions one by one. So the next question, what are the mandatory statutory requirements on employees, like the PF, pension, medical insurance, etc., especially on fresh graduates or trainees?
Right. Okay. So you do have statutory requirements, like you're absolutely right in terms of PF and gratuity, and your insurance that you do need to take. These are all dependent on the number of employees that you have. There are certain thresholds, individual ones. I can possibly, maybe after this call, maybe just circulate a checklist with Archana, who can then circulate it to you guys in terms of all the mandatory requirements. There are certain, and they all have different thresholds. Say if you cross 20 employees, certain if you cross 10. So that would vary depending on the number of people that you've got. So that's something that I'll probably share with Archana, and she can circulate that with you.
Yes, Roy. Thank you. So we have next question from Hiran Patel. Hiran, do you want to unmute yourself and go ahead with your question?
Yes, I will ask.
Yes, go ahead.
Hi, good evening.
Good evening. Yeah.
So my question is to some organization as I face the issues. When freshers, I apply the job, just I selected, but they ask me for 2 years bond, and it's a one-way bond. They're not ensured that about your job security, but as an employee, I have to give the assurity. Will stay at least 2 years. So in this case, what should I do in future if organization ask me to do?
Right. Okay. See, for instance, the basic premise actually is that bonds are not particularly legal in the country. So I know often there are contracts like this. Typically, what companies try and do in such circumstances is, which again which isn't right, is they sometimes take original certificates and keep them with them, and then say, no, this is part of our policy and things like that. But realistically speaking, they cannot bind you to a particular company. They cannot bind you for a particular period. If you have signed a contract like that, that could well be illegal, and that's something that could be challenged in a court of law as well. But from a practical perspective, so what companies sometimes try and do is they say, okay, here's a training cost. So for the 2 years that you have, this is the training cost. If you leave before that 2 year period, you need to end up paying me X amount or whatever that training cost is. So that they try and they have different mechanisms of trying to keep you in a particular place for a longer period of time. But legally speaking, you can't bind someone to an employment for any amount of time.
Thanks.
I hope that answers Hiran's question.
Yes,
So,
yes.
yeah, thank you. So next we have question from ITM Incubation Cell. Can you unmute yourself and go ahead with the question?
Yeah. So this is Padmamalini. I just wanted to know, usually when the startup is created, that time parents also take some kind of shareholding structure. So do you see, is there a difference between parents taking and where the impact will be coming in the long run? That is one part of the question. The other question I have is, some startups will have will have a co-founder who is already running 2 or 3 startups. So, what do you think? Where do you think that will lead to some challenge, or is it a good thing to choose that kind of a co-founder? So, these are the two questions.
Sure. No, that's a great question, and I think that's really important because, see, for instance, that's one of the reasons why in the co-founders agreement it's important that you put in and you have in place what each person is bringing to the table. For instance, this whole example of you having parents as co-founders, honestly, this may be only for a statutory requirement where you need to have two shareholders. So the individual may not necessarily be contributing, the parent may not be contributing in any manner to the business. So when there will be a problem is, say they want to bring in a round of investment, and all of a sudden they find that there's one person who's just holding these shares who are not actually doing anything, not contributing to the company, right? So then that's when you will have an issue. So even if you are getting in touch with, even if you are setting up with parents, it's important that the shareholding pattern or the division of the company and who's getting is clarified at the start, and also saying that, okay, their contribution is nothing. Maybe they invested in at that start, maybe it was the capital for the beginning, so you can ascribe an amount, but it need not be at 50-50 to begin with. It could be somewhere along the lines of even 97 versus 3%, because their contribution is only limited to that. So that's on the parent front. If you're talking about having co-founders who are co-founders in multiple startups, again, it's important that you list out what they're actually bringing to the table. Maybe they're bringing in their connects, maybe they're bringing in their network with other investors, but it's important that you list that out, saying this is what the reason why we're making you or adding you on this is for this, and these are your deliverables. Supposing they tell you, no, I'm a co-founder with 3-4 companies, I have great connects with VCs, so take me on, but then it needs to be like, okay, fine, are they going to set up meetings with VCs? If so, how many are they going to do per month? If they don't do that per month, what can I do? How can I make sure that they exit from this without them just hanging on into the company and not contributing?
Okay. Thank you.
Sure, no worries.
Thank you, Padma. Thank you, sir. So So next, we have few questions from Jnana Krishnan again.
Right.
Jnana Krishnan, would you please able to unmute yourself and go ahead with your question now?
Hello.
Yes,
Yeah.
go ahead, sir, with your question.
Yeah, good evening. So this is Professor Lady Krishnan.
Good evening.
My question is this: during the probation and after the confirmation of the probation, is there any policies favoring the employer, sir? Because especially software companies, they do the layoff of many engineers. I just wanted to know, as an employer, what are the benefits it is favoring them, and what are the legal complications faced by them?
Okay, no. So are you saying that on the part of the company, what are the policies that are favoring them? See, the thing is, policies are drafted by the companies or the people running the companies. So chances are they may be a little one-sided. But that's why so the angle that I'd mentioned on this is if you are employing individuals, that you have these policies in place. In terms of whether or not they are one-sided, that could be entirely up to the way that they are drafted. You may have companies which have policies which are quite fair and equitable, whereas you may have companies that have restrictive trade practices. The important thing is that is the culture, or that is the way that particular company is run. So sometimes those policies may have grounds for termination, they may have grounds for layoffs, they may have all these things written in as a part of their policy itself. And so typically what happens is when you sign up with when you do join employment with them, you will be presented with at least links to all these policies for you to read. So the idea is at that stage, if there's something that you fundamentally disagree on, you technically don't continue there, but it's highly unlikely. So in terms of your question, yes, there are policies that would favor employers, but for the simple reason that they are written by the employers in most cases. And it could be one-sided, but it is the way that that particular company is run. It cannot, of course, be completely illegal. They cannot have policies which are illegal. Like they cannot say that, we're not going to give women employees maternity benefits. That even if that's the company's policy, they cannot enforce that because that is something that's illegal. So as long as it is legal, they do have a certain amount of control over the way that the business is run.
Okay, so my another question: can an employer sign a 2 years bond with the employee? Because sometimes they send the employee for training abroad, or they may incur huge training expenses. So, can they have a legal bonding with the employee for a set period?
So typically, calling it a bond would be a problem because that isn't exactly legal. So what they would do, like I was just explaining, I think to Mr. Hiren Patel some time back, what they tend to do is they tend to say, okay, fine, we're incurring X amount of costs, and I've seen some clients and some companies do that, saying, your training period doing all of this, giving you this opportunity is valued at say 5 lakhs. So if you want to leave within this period of 2-year period, you need to return that amount of money to us, or some sort of mechanism that's there like that, so that they try and keep you on for 2 years, right? Because from the company's perspective, they are investing in you so that but at the same time, they're also gaining something from you. So the idea is you can't sign saying I'm not going to work anywhere else for the next 2 years, because there are certain contracts, like certain agreements like that, which are downright illegal, because you cannot bind someone or restrict someone's trade or practice. There may be certain reasonable measures, but so it'll vary from contract to contract in the way that it is drafted. But if it's an outright bond saying, from now until 2022, you cannot work with anyone other than me, and you only have to work for me, sort of thing, that could well be, we'd have to check the legality of that agreement, because it may not be legal.
Thank you so
Thank
much.
you. Thank you,
Sure.
Roy. So, in the interest of time, we'll take the last question from the chat box.
Sure.
Is there any important aspects, those related on co-founder agreement for Star and Brain, which you would like to suggest? That is when co-founder with the business background gets along with the co-founder based on technology.
Fair enough. And honestly, I would say the important aspect again is roles and responsibilities. Make sure that you have it's very clear as to who's contributing to what. That's number one, roles and responsibilities. And the second one is who makes what decisions. If you've got someone who's really good on the business front, you can, in case of a disagreement, let that person take that call because of their background. So it's important that you have roles and responsibilities and also who makes what decisions. These are the two things that I would say would be absolutely essential if you've got that sort of a combination.
Thank you, Roy. Hope that answers Iha's question. So before we wrap up, I would like to make a few announcements. I've posted the feedback form link in the chat box, so requesting the participants to please fill the form for us to improve the upcoming Knowledge Tuesday sessions. We are hosting an Ask Me Anything session on the coming Thursday at 5 p.m. on the topic Ask Me Anything on early stage startup investments by Vasu Guruswamy, who is a founding partner of Lavni Ventures and venture partner CSL Ventures. Roy, we would upload the video session on our YouTube channel for people who have missed. So I hope it is fine with you.
Sure, that's good. No worries.
Thank you, Roy. Thank you for your time. It was
Pleasure.
really useful and informative session, and I hope the participants also been informative through the session. Thank you, Roy, once again.
Sure, my pleasure. Thank you.
Thank you, Roy. Thank you all the participants. Have a good evening.